Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS legal hotline lawyer. I'm sometimes asked, what question is the question that I receive more than any other? And my response is typically that it depends entirely upon the market. But really, truly, over the course of time, the one question that never goes away is the question that asks something along the lines of, here's the condition on seller's property. Do I or the seller have to disclose this condition? The question being, what does the listing broker or the seller have to disclose with respect to the condition of the seller's property? And the only answer I can ever give to that question is, listing broker, if your seller needs help figuring out what they have to disclose, you must advise your seller to seek legal counsel. Anytime you take the facts of the seller's situation, apply it to the law, reach a conclusion about what has to be disclosed, you are practicing law. Real estate brokers are not licensed or insured to practice law, and so you've got to advise that seller to seek legal counsel. Brokers, if you're not sure what you have to disclose, number one, work with your managing broker to try and determine whether or not you have to make a disclosure. Remember that your disclosure obligations are regulated by both the agency law duty to disclose material facts and the Seller's Disclosure Act requirement that brokers correct known errors, omissions, and inaccuracies in the seller's disclosure statement. So I know that sometimes when I say this, that brokers, you can't advise sellers as to what they have to say on the seller's disclosure statement or whether or not facts have to be disclosed. The response is kind of one of frustration. What is the seller hiring us for if we can't give them an answer as simple as yes, you do or no, you don't have to disclose that issue? But again, recognizing that it is the practice of law to do that and you're not licensed or insured to do that, the agency law requirement that you advise your client to seek the advice of an expert in areas that exceed the scope of your expertise kicks in. That's the law, and maybe that's the only explanation I should have to give you as to why you can't answer seller's question of, do I have to disclose this? But sometimes illustrations help, and so I have two illustrations, and these both come out of questions that have been asked in the last week about specific disclosure issues, and they help to illustrate why a broker should not answer this specific question. The first one is, does the seller have to disclose that a murder occurred in the house? Now, when I pose that question in classes, overwhelmingly, the answer is yes, seller has to disclose that. And then, of course, I always follow up with, why? What's your basis for saying that? Because the fact is, there is nothing in Washington law, case law or statutory law, that answers the question. I'm not telling you seller doesn't have to disclose it. I'm also not telling you seller does have to disclose it. And the reason I'm not telling you which the answer is because Washington law doesn't instruct us with respect to this issue. There are states out there that have statutory law directing sellers that they either do have to disclose death in the home, don't have to disclose death in the home, or that it has to be disclosed under a certain set of circumstances. Washington doesn't have that law. And Washington courts have not addressed this issue. Now perhaps you'll say, but there's no question on the Form 17, there's no question on the Seller's Disclosure Act asking that information. But then again, maybe there is. The very last question on the seller's disclosure statement asks if there's anything else a buyer should know. At least one court, not Washington, has looked at a similar question on the seller's required disclosure statement where the seller chose not to disclose a death in the home. And the highest court in that state sent the question back to the jury for reconsideration saying, this question, what else should a buyer know? It's conceivable that that triggers the requirement for seller to disclose this issue. That court said the jury should make this determination. The seller should not have decided necessarily that buyer doesn't need this information. In that case, that was a Pennsylvania court, the court said, let's let a jury make this decision as to whether or not this is information that a reasonable buyer would want to know. If you're the listing broker and you've told seller you don't have to disclose that, and then it finds itself in a courtroom being answered, that question finds itself in a courtroom being answered, and the Washington State Supreme Court said, we don't know the answer to this question, let's let a jury answer it. Listing broker, you got a problem. Second issue that is a little bit harder to define than it might seem. The question is, seller's home was once a meth manufacturing site, but it's been abated. It's been remediated. In fact, the Department of Health issued a certificate that the property is clean. Does the seller now have to disclose that the home was once a meth manufacturing site? Seems like it could be an easy answer, depending on whether you're looking at common law or statutory law. Washington Supreme Court has said if a condition on seller's property has been remediated, seller has a reasonable basis for believing that a past condition has been corrected, seller has no obligation to disclose that condition. But the Seller's Disclosure Act asks this question specifically of seller. Form 17, one of the questions is, has the home been used as a illegal drug manufacturing site? The form doesn't ask if the property was once but has now been cleaned. It just asks if it was ever an illegal drug manufacturing site. So how does the seller treat that issue? If they don't want to disclose it, but the question asks that specifically, can they rely on the court's more generalized statement that abated conditions, remediated conditions don't have to be disclosed? Broker, you can't give the seller that answer. Advise that seller to seek legal counsel. And as is always the case when you advise a seller to seek legal counsel, or your buyer, whomever you represent, document that advice in writing and deliver it in a provable way, so that if later it becomes necessary to prove that you gave your client the advice to seek legal counsel, you'll be able to do so. If you have questions on this topic or any other, please send an email to me, legalhotline@warealtor.org. Thank you for being a Washington REALTORS member.